This chapter in juvenile justice is about the future directions in criminal justice. Uh, Most importantly, in this chapter, we're looking at reform proposals. The model we talked about a couple chapters ago about restorative justice is really the new focus of the juvenile justice system. We're also going to look at some of the social issues that affect juveniles, as well as some of the Supreme Court cases that have impacted the way that the juvenile court is run, as well as the punishments that juveniles can receive. We'll also, in addition, discuss Graham versus Florida and Miller versus Alabama, which are about life without parole. We'll discuss the confusion over what is the role of the juvenile court concerning status offenders. And excuse me, and how do we address the problems of youth? How do we divert juveniles from committing crimes, from committing first crimes and recidivism? I want to go back just quickly to the other. I'm not going to go over the key terms, but I did highlight a couple that I think are very important and I would like you to take notice of through your readings. And the criminalized juvenile court, we've talked about this. If we criminalize juvenile court, then it is just like an adult court. As I mentioned, restorative justice in the juvenile court is extremely important and very successful. Roper versus Williams, we'll talk about, as well as the spiritual dimension in corrections and how can we use our own Christian worldview to impact the juvenile justice system? What can your beliefs do to make these improvements? And also therapeutic jurisprudence. This is a very important direction that many courts are taking, including juvenile justice. But we'll get to that in a little bit. Okay, back to where we need to be. As we have seen and as we have discussed, there are many criticisms of the current juvenile court, and there's many suggestions about how do we fix this problem. One of those suggestions is to try to return to the original intention of the juvenile court, where it was a rehabilitative court or a substitution for the parent for the troubled youth. The parens patriae theory that the parents aren't there and can't control their children, so the system was set up to fill in that void. We also discussed Mark Lipsy just the other day, and he again has done extensive research on what works in the juvenile justice system, and he has found that there are programs that work. They are doable. We can afford them, but it's just a matter of getting that buy-in to get those done. Uh, Kreisberg also, he argues over the morality of treating children as if they're your own. And Corbett also, too, he had some important um, focus on the interventions and showed and wanted the professionals within the system to set an example and act as a moral conscious, a moral educator. Many believe that the juvenile court is not rehabilitative enough. And so there's all kinds of ways that we can increase that rehabilitation, having a more positive outlook on what we can do to help children by involving probation officers and social workers and more professionals within the court. The current philosophy is if it is really enacted correctly, I think it would be very successful because what we see in the system is, if a child commits a minor offense at a young age, we tend to overlook it, divert it. Oh, they're okay, send them home. We don't have time for them in the system. But if we can add more mentors to the system, then we can stop those repeated offenses if we can address them when they first begin, even just in acting out behavior, including a less punitive and more treatment within the placements is also a positive. The other suggestion that has come from um, advocates and supporters uh, is to criminalize the court, to make it a scaled down version of the adult criminal court with all of the same procedural protections of criminal court, such as jury trials. And we have done this in many of the due process cases, but as we know, it's not completely the criminal court. It would make it more punitive. Barry Feld, he is one that argues that the juvenile court has failed, and he is of the belief that we don't need the juvenile court, that we should abolish it. He also argues that the court doesn't provide the same fairness to children as it does to adults. And if you look at right here, he sums it up that the current juvenile court provides neither therapy or justice and cannot be rehabilitated. I want you to really take note of that. I actually have that in many of my papers. I think it speaks to the heart of what our problem is right now. And what he means by this is really very depressing, that he's saying that our juvenile court doesn't work, that it's not following its original philosophy of um, parens patriae. It's not offering any rehabilitation. It's also not offering any justice to the children that are in it, as well as it can never be corrected. He goes on to say that if the court is abolished, then juveniles would receive the same procedural protections that adults do, but he does say that juveniles should still receive shorter sentences. Vandervoort and Ladd argue against the separation, and they state that as we see, the criminal court is very harmful to adolescents. In fact, it can increase recidivism. In fact, it does increase recidivism, and that juveniles are really just getting punished in adult court. They're not being rehabilitated. They're not getting any treatment, and that goes back to what Feld just said, that that's what he believes the juvenile court is at. The As I mentioned a minute ago about Noriega suggesting that there be a rehabilitative children's court for the younger youth and a more punitive court for adolescents. And he suggests that we create a new court with these two branches, one for children and one for adolescents. And under that new court, waivers would be by judicial hearing only. There would be no more automatic waiver, legislative waiver, or prosecutorial waiver, and it would only be the next step. So children could only be waived there. Um, Children could only be waived to adolescent court, and only adolescents could be waived to adult court. So just make sure you understand what he is saying. He's really looking at three courts: a small children's court where you have even maybe status offenses, but those that have committed minor crimes, and then you have an adolescent court that deals with the more violent crimes and the more serious. So youth can be transferred from one court to the other depending on their risk level as well as their offense. Of course, this means a more complex system than what we have now. Now, Buds, he thinks that the juvenile system is just too far gone, and he suggests a new youth justice system within the adult court. His ideas would ensure more quality of the process used for all youth. And this is centering around the new movement, what we call therapeutic jurisprudence model of drug and mental health courts. And this is being seen now within the mental health courts, the specialty courts that we talked about, the problem-solving courts. It attempts to treat the problems of youth with judicial supervision over treatment. Um, I know I've mentioned it to this class, but there's a law professor that passed away, and he was very adamant about our system, and especially our juvenile justice system, that we are all helping professionals, from probation officers, attorneys, district attorney, judges, uh, um, probation officers, parole officers, that it's our job to help any individual that comes into the system. And that's what therapeutic jurisprudence is all about. And the current system is, even though We still see youth transferred, we still see youth incarcerated. It has become less punitive, and we've seen a decline in in more serious crimes and the need for harsh punishment. This is this move towards more diversionary programs. And a lot of advocates are really pushing for holding juveniles accountable, which is our classical school. That an individual, if they commit a crime or if they act in delinquent behavior, they should be held accountable for their actions, whether it's through um, restitution, it could be through punitive, but it doesn't have to be um, so punitive and harsh that the punishments outweighing the the consequences of their actions. And this is where we move to the Restorative Justice Court. Bazemore is a huge advocate, and you should see his name quite frequently when we talk about restorative justice. But he suggests that the juvenile courts adopt the restorative justice model and focus on both the victim and the community, just what we talked about. He also thinks that the juvenile justice needs to include both the victim and the community throughout the process. He thinks that the juvenile justice needs to include in the court process so that the offender, not only is he held accountable, but the community can also assist in restoring the victim and the offender to positive situations. Many times, a community can offer new ideas and original ideas instead of just the people that are involved. And a survey of judges actually showed that they are also in favor of the restorative justice model. We can't talk about improvements to the system without talking about the racial disparity that we see within our courts. Um, some renowned researchers see that the problems of the juvenile court do not exist in a vacuum. In other words, there are other problems from society, there's problems of racism, there's problems of declining civic involvement in community social capital, there's the decline of the family that we've talked about, and there's the weakening of character education. That's all contribute to delinquency in juveniles. Individuals are spending less time together. And this goes back to the restorative justice model, because if you involve the community and you involve all of the people that are impacted, you're going to have more collaboration, and it's going to bring those people together that have divided for any number of reasons, whether it be society problems, whether it's racism, whether it's the lack of involvement. As we talked about before, family is critical. Involving the family, the the support that a family has, those are all critical to helping a juvenile not recidivate as well as avoid delinquency. Family support, social support, all of these aspects help prevent delinquency. Early prevention programs in schools, involving the schools, the parents, community, teachers, criminal justice professionals, the members of juvenile justice, restorative justice programs, therapeutic jurisprudence advocates, involving all of these people, we can work together to stop delinquency. And remember, we talked about theory earlier about less parental guidance, less supervision, and this also leads to an increase in delinquency. There's also talk that the changes in the political economy, such as less government funding for treatment programs, these have also contributed to the current, excuse me, I moved my mouse there, jumped around. Let me think back what I was saying. Um, Government funding for programs, they have contributed to the current emphasis on punishment and deterrence rather than rehabilitation. Some suggest that corrections and juvenile justice return to some sort of emphasis on the spiritual dimension to help offenders find greater meaning within their lives. Mhm. Whitehead and Braswell are two researchers that have been working with restorative justice and the spiritual dimension in corrections and with this within the system. And this is the basis falls on character education. If we can focus on the meaning behind the purpose of life, we can help build that foundation that is lacking. And many institutions and programs now are taking certain steps to incorporate this spiritual dimension into the practices. And this doesn't mean a specific denomination. It means encouraging offenders to think about the meaning of their own lives, have some kind of spiritual framework that they believe in, and that they can use that belief to guide their lives. And character education can happen anywhere. It can happen at home, happen in the schools, it can happen in training schools. It's just a matter of incorporating this as well as incorporating the other suggestions that we've seen. There is evidence that bringing in these spiritual dimensions and offering a spiritual framework in corrections is inversely related to carrying weapons. And some object that it's too ambitious to help these offenders spiritually. Though you hear also, oh, I found Jesus, so let me out of prison, and that's not what we're talking about here. We're talking about a change in the way that they perceive their own lives and their own meaning and purpose. Oh, that's what we got the problem here. There we go. No wonder. Sorry about that, everybody. Now we're going to move to talking more about the capital punishment for juveniles. As we know, capital punishment is no longer considered uh, is constitutional according to the Supreme Court. And in 2012, we're just going to look at this a little bit. There were 443 homicides that were committed by juveniles. The death penalty for juveniles has been debated a long time. In fact, as we know, it's debated in every state for every age. It's debated for mental health, individuals suffering from mental health. But in 2005, Supreme Court ruled the death penalty is unconstitutional for juveniles. In addition, um, over 2,500 persons serving life without parole sentences who were under 18 at the time of their crimes. Graham versus Florida banned life without parole for juveniles, but only for those not convicted of homicide. And Miller versus Alabama banned the mandatory imposition of life without parole for juveniles, restricting it to an individualized consideration of the youth and what their offense was. So in other words, it can still be sentenced, but it's only for those most serious, and it's supposed to be indeterminate. And I'm not going to read through this table in this box. You can look at this in your book, but you can see that there are certain states that have a minimum sentence for juveniles instead of life without parole. And the only thing I want to mention here is like, look here at Texas. A 40-year sentence to a 15-year-old is a life sentence. You're telling that child he's going to be in jail three, four times longer than he has even been alive. And as we know, we've talked about this, incarceration, jail, detention, these exasperate already current problems that a juvenile might have. It increases their trauma. They can experience severe trauma in prisons. Not only are they subjected to physical threats, violence, even death, um, in life without parole, many times there is no treatment offered. many states and many advocates of the punitive um, traditional focus think, why should we give treatment and rehabilitation to individuals with life without parole? They're never going to use it. They're never going to get out. So it's under a constant debate. But there's the argument that if a juvenile is too immature to be executed, that they don't understand the clear um, logic behind that. Isn't that the same thing true of life without parole? One of the last things that we're going to talk about in this chapter is the elimination of the juvenile court's jurisdiction over status offenses. Many argue for eliminating the juvenile court's jurisdiction for things such as truancy, runaways, incorrigible youths, and proponents of this divestiture argue, argue for the need for court intervention into these problems. Research does not note that protective factors such as parents that actually supervise teachers, that they can actually help delinquency. So whether the juvenile court has jurisdiction or not, it is clear that society has to pay attention to these problems. You know, look at this, a considerable portion of juvenile court time and effort is spent on status offenses, 137,000 in 2010. So if we stop the court's jurisdiction over status offenses, the court will have more time and energy and resources to deal with those youth that really need those services. And it recognizes that juvenile courts are not adequately staffed, and it forces intervention to be voluntary from the juvenile as well as the family. And prosecuting status offenders is often a blame the victim approach that really ignores the real causes of the problem. If they're doing something, and that's where we need to come together as a community, teachers, parents, to work together to find out what is causing this adolescent to act out in the ways that they are. Also, too, I don't want to overlook this. And remember, we were talking about the young man that spent in Rikers, that spent a number of months and years for stealing a backpack. And he was mistreated while in prison. And when he does get out, he's finally, he goes quite a while. Everybody thinks he's doing well, but he commits suicide. And it's because it was the courts were violating his due process rights. And we're talking about, it was a status offense. Let me correct that. That was not a status offense because he did steal a backpack, but it's under the same minor offense as you would have a status offense. There's also those that continue to argue that the court does need to have jurisdiction over status offenses. And some of those arguments are here, that parents and schools can't even handle it, that if there's no backup from the police to come to the school, that the juvenile is going to continue. And also that status offenses contribute to more criminal offenses. And last but not least, in this chapter, our goal as criminal justice professionals, not only with the juveniles but with any court system, we have to focus on prevention strategies, and especially with adolescents, we have to learn how to reduce the risk factors and enhance protective factors in order to find the best method to prevent problematic delinquency. We need to find the problem behind the delinquency and help that juvenile work through that.